The honourable member. Order. Order. You're stopping the member for Melbourne Ports from starting his contribution.
For many years, I have never been in a debate or seen a debate or heard a debate where the people defending a government minister fail to mention him entirely in two contributions. This is the member that, as just suggested, who dare not speak his name. The current member for Fisher stood in this chamber and declared the federal court had exonerated him in regards to claims that he'd encouraged James Ashby to breach Section 70 of the Crimes Act of 1914 and 478.1 of the Criminal Code 95 by procuring the Speaker's official diary, so forensically drawn out by the member for Isaacs in several question times. The current member for Fisher said in this chamber last Thursday, 26 November, and I quote, in defence of his and the government's integrity, the findings of the full bench of the federal court, which dealt with all the evidence put before it, found entirely that I acted appropriately. The current member for Fisher has subsequently made numerous references to the federal court decision, including yesterday, where he made explicit references to paragraphs 122 and 124. But the federal court has made no judgment on this. The current member for Fisher was neither found guilty nor innocent of this allegation, as the member for Isaacs pointed out. For him to suggest otherwise signifies at the very least a misunderstanding of the judicial process. Mr Speaker, if the current member for Fisher continues to make this claim, he would run the risk of misleading this parliament. To recount, on 12 December 2012, Judge Reres threw out James Ashby's claims against Peter Slipper on the grounds of abusive process. In that decision, the judge savaged many people, not the least the current member for Fisher. Reres found that, quote, Mr Ashby and Ms Doan were in combination with Mr Brough to cause Mr Slipper as much political and public damage as they could inflict on him. And further, the judge added, Mr Brough was unlikely to have been offering to assist Ms Doan and Mr Ashby out of pure altruism. Realistically, his preparedness to act for them was created and fed by their willingness to act against Mr Slipper's interest and to assist Mr Brough and the LNP's interest in destabilising Mr Slipper's position as Speaker and damaging him in the eyes of the electorate. Ashby sought leave to appeal, and that was granted on 27 February 2014. In that judgment, their honours held in paragraph 122, the very paragraph that the current member for Fisher cited, and I quote, that Brough was prepared to look at evidence produced by Ashby. This does not necessarily mean that his purpose was to harm Slipper politically, just as the member for Isaacs pointed out, does not necessarily mean. The current member for Fisher mistakenly believes this vindicates him. But the paragraph is clear that the court did not decide the question of procuring the diary excerpts. It merely stated it does not necessarily mean that the current member for Fisher was motivated in that way. Later, more importantly, on 9 February 2015, the federal court upheld Ashby's appeal on the grounds of procedural fairness. The judges once again addressed the current member for Fisher's involvement, but once again did not pass judgment on it. Paragraph 146 of that judgment, February 2015, says, there is no doubt that Slipper's allegations in relation to Ashby's purpose for instituting these primary proceedings were serious. As it transpired, the full court did not share the view of the primary judge. It was correct to have acceded to the summary dismissal of the application. This does not amount, the judges said, to the full court making positive findings in favour of Ashby. It does not invoke any specific findings of fact in his favour. There has not been a trial of these issues, the judges said. The relevant evidence has not been given. The reliability of witnesses has not been exposed to testing by cross-examination. In event, as noted above, that will not occur because Ashby has discontinued the proceedings. The court said that the evidence hadn't been tested. There is new evidence, however, that will come out if this is looked at further. On 60 Minutes, as the member for Isaacs pointed out, the journalist Hayes asked the member for Fisher, did you ask James Ashby to procure copies of Peter Slipper's diary? The current member for Fisher's answer was, yes, I did. Hayes continued, do you think it was the right thing to do? The member for Fisher answered, let others be the judge of that. Speaker, That's exactly what this parliament is doing. We are making a judgment on the ethics, morality and integrity of this government and the member for Fisher, and I'm sure it will be found wanting if those claims made on 60 Minutes are accurate.
I thank the honourable member for